So Tracy, to that point, when is a probate required in a sale transaction? Maybe you could talk
Right.
about how this really.
So a probate is required when there isn't vesting in which you have title with somebody else with right of survivorship. So if you have husband and wife as joint tenants, then joint tenancy, the beauty of it is the right of survivorship. If one passes, the interest automatically goes to the other. Same with community property. If one passes, it goes to the other. In a trust, beautiful thing. You hold title in your trust. The trust will account for what happens when you die. So probate is, in that case, not needed typically because it will say within the trust agreement who the next signer is and be very helpful for us. It's our guide. In the case of an individual being on title by themselves to their interest specifically, when they die, you and I can't say who's to be a signer. Only a judge can say that. So at that point, when there's just one person on title as an individual specifically to their interest, then it has to be probated. Everything gets gathered, taken with attorney representation, typically to a judge, and then they proceed. There's a couple routes of probate that they may take, but
No, if they do, one of the questions that I get asked in escrow and is if they have a will, right, that says my child gets everything that I have.
that's what you take to court.
So you
still have to go to probate.
probate.
Yeah,
Yes.
will is not a way of acquiring title, it doesn't transfer. That's why trusts are created when you do estate planning. A trust is a way of holding title. A will is a way of saying what your wishes are. Power of attorney is to have somebody to sign on your behalf as an individual while you're alive. Estate planning covers those things, but it's not a way of holding title. It's information to take with you to court.